of the judge of our Court of Appeals, and Judge Richard Walker, a senior judge, is with us this morning. The case that we have set next is case number 122-358/122891. Is Legato LLC versus the City of Olathe, Woodbury Corporation, Great Olathe Center LLC, and Beth Wright appellees. Now I need to get the appearing for the appellant this morning.
Good morning, John Duggan. I'm sorry, John Duggan on behalf of Legato LLC.
Appearing for the City of Olathe.
Your Honor, Leslie Greathouse, and I'm also appearing for Beth Wright.
Excuse me. Appearing for Woodbury Corporation.
Jerry Sellers.
Appearing for Great Olathe Center LLC.
Good morning, Your Honor. Jason Scheider, appearing on behalf of Great Olathe Center.
And let me ask you, I still have some other attorneys listed under the defendants. Have I left out anyone else that is here, but I haven't I received a name appearing for any of these particular defendants?
No, Your Honor. You have everyone.
Do I have everyone?
Yes.
Let me ask you, we only have 15 minutes aside for this case. Are some of these particular defendants, are they unified with their arguments?
I will be arguing on behalf of all the appellees.
Okay, is that okay with the other counsel for the defendants? For Ms. Greenhouse to make the argument for all the defendants are present here.
Woodbury agrees, Your Honor.
In Your Honor, Great Olathe Center also agrees.
Okay, well, Ms. Greathouse, are you ready to proceed with? Well, let me get back. I need to deal with the appellant. Mr. Duggan, are you ready to proceed with your argument?
Yes, Your Honor.
And do you want any rebuttal time?
Yes, please. 3 minutes.
3 minutes? Okay. We're ready to hear your argument.
Thank you, John Duggan on behalf of Legato. May it please the court. Unambiguous, fully integrated, specific easement agreements which contain a commonly used phrase, more or less, to describe the area of the easement to 1/100th of an acre, are not blanket easements or subject to what a reasonable person believes the easement is. To add a reasonable person fudge factor to a precise meets and bounds legal description, which describes a unique geographic area on the face of the planet Earth, would be to open a floodgate of potential litigation across the state of Kansas, allowing anyone to argue that the easement was actually more because there was an effort to describe these oblong shapes, which are not perfect rounded numbers, to 1/100th of an acre. As such, this is important to my client because my client gave the city of Olathe a specific easement grant of a number of oblong shaped areas on my client's property to allow water to pass through those areas downstream to a discharge point. At the present time, my client's allegations are that water, mud, and silt go beyond the boundaries of that meets and bounds legal description. And moreover, that there's never been a grant to the city to discharge mud, soil, and silt inside the easement boundaries. In fact, all of the mud and the silt that's been discharged inside the easement boundaries constitutes a pollutant under the Federal Clean Water Act that will require remediation and an EPA permit to effectuate. So my client's reason for appealing the district court's ruling is first and foremost that the district court, trying to find a middle ground between my client's assertions that it had a very specific meets and bounds legal description juxtaposed to the city's position and the other defendants that they could flood my client wherever they needed to because there was a more or less tail on the end of the legal description. The judge struck a middle ground and he said, I believe it's a specific easement. It's a fully integrated, unambiguous document, but because the words more or less are on the end of it, I think a reasonable person could construe it to be perhaps a tenth of an acre or thereabouts, maybe a third of an acre, some fudge factor above or below that number. I think that's a slippery slope for the state of Kansas courts to get onto because there's no end. Now we're going to submit to juries what would be reasonable to determine what the terms more or less mean. That, therefore, in my opinion, and this is what we suggested to the district court, by reaching the conclusion that this fully integrated, unambiguous document means what it says and says what it means. These oblong-shaped areas are specific and discrete in their boundaries, and that the city has no legal authority to allow water to go beyond those boundaries, that triggers all the causes of action in Legato 1, the first lawsuit, including an unlawful taking of our property because the city approved a rezoning which was based upon a preliminary stormwater plan that showed my client's property would be a wetlands discharge area for their neighbor.
Excuse me, Mr. Duggan, would you stop? One of the judges cannot hear your argument.
I'm sorry, can everyone else hear me? Because I can
hear fine.
Richard, can you hear?
Oh, yes.
I'm able to hear.
Judge Schroeder, I can raise my volume. Does that help?
Judge Schroeder, Kim, can you hear me?
Apparently not. Wonder if he's got his mute on.
I do not have my mute on.
No, I'm talking about.
We wonder if Judge Schroeder has the mute on.
I can hear Judge Schroeder.
Kathleen, can you hear me?
I can hear everyone just fine. I'm not sure what the problem is from Judge Schroeder's audio, if he was able to hear earlier, but
He sent a message that maybe could we start over?
If he can you hear me now? I'm happy to start over, Judge, if you can hear me now. I think his hand by his ear means he can't hear.
I agree. We can pause the argument and have Judge Schroeder rejoin the argument.
Maybe that's a good idea.
Yes, I believe we've done that before.